Hello, today I will start examining the topic of peaceful settlement of disputes in international law. This video is the first covering the topic of international settlement of disputes in international law. It explains the scope of our explanations that are confined to general international law and interstate disputes. We address the concept of dispute and the principles that govern the settlement of disputes between states. Our second video introduces the typology of settlement of dispute mechanisms that can be more commonly encountered based on state practice. As usual, all our explanations will be illustrated with case studies from all over the world. I think actually all the continents are represented in the next few videos. A third recording will then explain what we call diplomatic means of resolving disputes, using, as I said, specific examples that should help you understand the legal regime. I will then do the same in a fourth video focusing on the so-called legal mechanisms. Finally, a fifth session addresses in more detail the role and functioning of the International Court of Justice. While the focus is always on interstate disputes governed by international law, I will use a separate recording to acknowledge and highlight the existence of a wide variety of mechanisms that are used by a state and other non-state actors to resolve conflicts in the international arena. I will outline some of the possible actors other than states that can be involved in an international dispute, and I will also very briefly point to specific fields of international law that have their own regimes and mechanisms to resolve disputes. Please remember that two of the pre-recorded videos by Professor Sheibas that are already posted for our international law lectures focus on the case of the Gambia versus Myanmar pending before the International Court of Justice and where he acts as counsel for Myanmar. They will reinforce your understanding of the functioning of the International Court of Justice and the topic of settlement of disputes between states. These sessions focus on disputes between states and regulated by general international law. In addition, we will refer often to the specific role of some organs of the United Nations in the settlement of international disputes, including the Secretary General, the Security Council, in dealing with disputes that are identified as threats to peace and security, as well as the International Court of Justice. Some of the functions performed by organs of the United Nations will be also addressed in the context of explanations that cover the topic on enforcement of international law, as well as the topic of the legality of the use of force. So we will see more about the role of the United Nations organs in settling disputes outside the topic of settlement of dispute, but obviously related topics such as the topic of enforcement of disputes and the use of armed force. So, therefore, in addition to the general rules of international law governing interstate disputes, we are also paying attention to the specific role of some organs of the United Nations in the settlement of international disputes. This is because the United Nations actions are relevant for every member of the international community. However, apart from this, remember that there are many specific settlement of dispute mechanisms that have been developed within other international organizations and for specific fields of international law, such as trade law or international law of the sea. In addition, international disputes are not only confined to disputes between states. As I have already advanced, I will outline some of the existing mechanisms outside the main focus of our lectures at the end of these explanations on what will constitute video number 6. Two main principles govern the settlement of disputes between states. First of all, states must resolve their disputes peacefully. We will delve further on this issue when we examine the legal regime governing the use of armed force in international law. For the time being, it is enough to advance that this is pretty much the only limit states must adhere to in resolving conflicts with other states. I will clarify this again when we explore the topic of the legality of the use of force. But please bear in mind that the prohibition of the use of force is understood as armed force. Therefore, states can and indeed use methods of resolving disputes that involve other forms of pressure over other states, taking advantage of their superiority, whether that is military, economic, strategic superiority, to force the settlement of conflicts. Apart from this, states are absolutely free of deciding how to resolve their disputes with other states. This is a feature of their sovereignty. The state is the ultimate authority in international law and therefore not subjected to the powers of another state or another international body to dictate how to resolve a dispute. Unless a state has consented to a specific means of resolving a dispute, normally by treaty, there is no general obligation to choose a particular mechanism to resolve a dispute or to choose a mechanism at all. While states are free to choose the means they prefer to resolve their disputes, the general principle of behaving in good faith is applicable to the settlement of disputes too. Finally, Article 33 of the United Nations Charter imposes the obligation to seek a solution to the dispute through a specific means of settling disputes if such a dispute might represent a threat to peace and security. This is an obligation of means and not of results. In this sense, there is an obligation to cooperate or to seek cooperation to resolve the dispute in good faith for disputes that may endanger peace and security. Hence, the freedom in the choice of means coexists with an obligation to try to get to a settlement in good faith and to cooperate in good faith, intending to reach a fair and prompt solution to the dispute. Both principles, the obligation to resolve disputes peacefully and the freedom of choice, are customary rules of international law that have been given written articulation and reinforced in their legal authority by including them in many treaties as well as in declarations adopted by international organizations. I am reproducing here Articles 2 and 33 of the UN Charter, as well as Article 1 of the Manila Declaration on the Peaceful Settlement of Disputes. Both documents are among the most commonly cited when referring to the written codification of the main principles governing settlement of disputes. As you know, the UN Charter is the treaty creating the United Nations. The Manila Declaration on the Peaceful Settlement of Disputes between States is a UN General Assembly resolution adopted in 1982. The initiative and drafting of the declaration came from non-aligned countries, in particular Egypt, Indonesia, Mexico, Nigeria, Philippines, Romania, Sierra Leone, and Tunisia. The UN Audiovisual Library has a link to a 10-minute video on the adoption of the Manila Declaration that you may want to watch. Before we start examining the different means states use in practice to resolve their disputes, let's devote a couple of minutes to clarify the meaning of dispute in international law. What is a dispute might seem quite straightforward and was articulated in 1924 simply as a disagreement between two or more parties on a point of law or fact. This was articulated as such by the Permanent Court of International Justice in its judgment on objection to jurisdiction in the context of the Mauro-Mattis Palestinian concession case. A reminder here that the Permanent Court of International Justice was a main organ of the League of Nations created after the First World War and then replaced by the United Nations. The successor of the Permanent Court of International Justice, the International Court of Justice, has elaborated further the concept of dispute in international law. It did so in its 2011 judgment on the Georgia versus Russian Federation case. Here it confirms former jurisprudence that is cited in the paragraph that I have partially reproduced here. So if you go to this paragraph 30, you will find all the former cases where the International Court of Justice has engaged with the conceptual contours of dispute. It confirms that a dispute requires some level of notifications between the parties. So for a state to have a dispute with another state, both need to know that this dispute actually exists. Remember that in the context of the explanations on state responsibility, we also saw that the International Law Commission's articles provide the need for the injured state to notify the allegedly responsible state about a breach of international law as the first step to claim its rights. A dispute can exist the moment the disagreement over laws or facts have been opposed to another party. It is, however, not necessary to prove that a specific means of settlement of disputes has been attempted. In summary, some level of communications between parties is required to establish the existence of a dispute. The International Court of Justice jurisprudence in this field suggests that the exchange between the states in a dispute does not need to be specifically hostile. It is enough that they formulate opposing positions to establish that the dispute exists. There is a conventional manner of categorizing settlement of dispute mechanisms, distinguishing between legal and political mechanisms. Disputes have also been categorized as legal or political, mainly to argue that some disputes cannot be settled by applying international law. These arguments have been advanced by scholars and states and have found some echo in the decisions of some mechanisms settling disputes. Therefore, it has some theoretical and practical relevance. However, the International Court of Justice has dismissed the difference, for instance, in the context of the Tehran hostage case that we covered in our session on state responsibility. In the context of our explanations on settlement of disputes, we are going to follow that line. All interstate disputes by their own nature will involve political considerations. In practice, the nature of the dispute will not depend so much on the facts, but on how the claimant articulates its claim. If a state makes the allegation that another state has behaved immorally, for instance, it will be difficult to settle the dispute applying international law. However, the same facts may lead to a claim that certain rights have been breached, facilitating a different legal approach to the dispute.